Let's head now, though, back to New Hampshire, where we've been watching Jason Levesque testifying, and he's now under cross-examination about how he shot and almost killed his neighbor.
Kyle, right?
That is correct.
And your claim is you got into the truck and pulled into your driveway and you made a joke.
I did.
Your claim to this jury is you made a joke to your daughter, 19 at the time?
Yes.
Should I run?
Yes.
And you suggest to the jury, to this court, that was to make light of the whole situation?
To lighten the mood, yes.
At that very moment, Kyle is 30 feet from you, dying in the street. Yeah?
That is correct.
And you want to lighten the moment is your claim? Isn't it true that even in your state, you were struggling with the basic notion of what you had just done?
That is correct.
You told the police, let me just make sure I'm accurate with this, at 20. Line 5. This is in the after the fact.
Sorry, I missed the page. What was the page number?
20, line 5.
What page?
What?
What page?
20, line 5.
Oh, 20, line 5, sorry.
No, my fault. Page 20, line 5.
Thank you.
You're talking to Garston, and you say, thinking back, and you're looking back on shooting him, and you say, you know, I made a bad decision. And you struggle with it. I don't know if I made a bad decision. This is the moment and the issue you're claiming you made light of?
That's correct.
You start by apologizing to Kira, saying, you know, I'm sorry.
Yes.
And isn't it true that not in a light, frivolous effort to lighten the mood, you were really concerned that you'd made a very bad decision, and you asked her whether you should run?
I was not looking for guidance in that. Like I said, it was an ill-made joke.
And she responded to you, didn't she? She said, not, ha, 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 that's a good one, Dad. She said, no, you shouldn't run, in a very serious.
That's correct.
And you responded again and said, well, what should I do? That wasn't a joke, right?
I don't remember that.
You're not saying it didn't happen?
I don't recall.
You recall talking to Kira?
I do recall talking to Kira.
And you're saying you don't remember saying, to your question, well, what should I do? You should stay. This is your path. I don't know what you should do, but this is your path. Remember that?
I do not remember those words, no.
Mr. Levesque, isn't it just true? I mean, as a matter of common sense, you asked Kira whether you should run because you knew what you did was wrong and you didn't want to face the consequences of it.
That is incorrect.
Then let's return to your plowing. You had told the police that you moved the snow into the front part of the driveway of my neighbor, where my neighbor's grass is, and then backed up, correct?
That is correct.
And look, I don't want to make too much of the snow thing, but you would just describe to the jury just not having any basis to even understand what Kyle was saying about not moving snow, correct?
I was referencing 39 Summer Street.
Okay. And so you can confirm, though, after the, quote, first snowstorm of that year, Kyle had approached you about putting snow on his property, and the response was, hey, something to the effect of, look, it'll melt.
That's incorrect. I've never had a discussion with Kyle before that evening about snow.
Did somebody else do you know whether anybody else in your family did?
Not to the best of my knowledge.
Like Kira?
Not to the best of my knowledge.
Okay. So your claim is that there hadn't been any discussions about where snow was to be deposited or not, right?
Can you be a little more clear about exactly what you're talking about and when?
Yeah, at any time prior to this night, there hadn't been any discussions, any disputes about where you put snow with respect to Kyle's property.
With Kyle?
Yeah.
Not with Kyle, no.
There had been this issue that you brought up about snow next to your maple tree.
That is correct. Not with Kyle.
Okay. But it happens that Kyle came out while you were, we can agree, still in the middle of this plowing operation.
That is correct.
Okay. You described to the police and to the jury getting out of your truck to manually adjust the hub so it went into four-wheel,
Yes.
and that you were going to back drag the snow out.
That is correct.
Wherever you were going to put that snow had just not yet happened, correct?
I hadn't even backdragged the snow yet.
So it hadn't happened yet. Wherever you were going to put it hadn't happened yet.
That's correct.
And here's the next thing that happens. You actually see Kyle coming out of his driveway, correct?
I saw Kyle approaching at some point.
Well, he was in his driveway, correct?
I'm not exactly sure what point it was.
Why don't you turn to page 34, line 4. Got it?
I do.
And you explained to Officer Garston you are manually locking his hubs. They're electric, so I got to have to do that. And, quote, that's when he came up the driveway.
That is correct.
So you saw him from, I don't know, 40 feet away at the first instance.
That's what that says.
What?
That's what that says. I don't remember that, but that's what that says.
Oh, I'm sorry, you don't remember the first time seeing Kyle?
I do not remember seeing him in the driveway.
All right. Do you can confirm for the jury that you went on to describe corroborated details, like down at the bottom of page 34. Yeah, and there I saw him come from. When I finally see him coming out of the driveway, you say it again, that's when you see him, right?
It does say that. And
You even describe what he's doing. He's putting on his shirt.
Yes, I do.
He was shirtless, so he was putting on his shirt.
Yes, I do. You asked me if I remembered that. I do not remember that. However, yes, I did state that.
But I guess there's this tension of you being tired that night with the issue of memory. You agree with me that's much closer in time to these events than your testimony today.
Yes, it was.
You agreed with me that that is a responsive statement to the officer. Well, you know, when did you see him? Yeah?
Yes.
You agree with me that that's a detailed statement about where you saw him and what his actions were.
I was doing my best to try and piece together what I remembered.
You did a good job. I mean, it's corroborated that he was coming out of his driveway putting his shirt on, right?
Yes, we saw the video. Yes, he was.
And so you'd agree with me. You got that one right.
Yes.
And so he's coming out of his driveway. You see him from this some 40 feet away. And just to confirm, you can see his hands, correct?
I don't remember.
You didn't see any weapons, correct?
Again, no, I did not see any weapons.
And as he's approaching that distance between his driveway when you first see him, you don't actually remember or know what he was saying, if anything, correct?
Sorry, could you ask me the question one more time?
Yeah, as he's approaching from the driveway, you don't actually know what he was saying, if anything, correct?
In the very beginning, I'm not sure if he had been yelling or what he had been saying. It wasn't until he was up closer to me that I had really started understanding what he was saying.
Okay, so when he's walking over, you're not claiming that he said anything at that point, correct?
I don't believe so, no.
You could hear a noise coming. You realized he's coming because you saw him.
I believe so.
And you actually described not only him putting on his shirt, but consistent with what we see on the video, you described that he was coming at a fairly fast pace.
Yes.
You confirmed to officers that as he's walking over, you could actually see his hands.
Yes.
They asked you details about that observations, and you claimed you were able to describe that as his hands appeared to be clenched.
When I did notice him and he was close to me, yes, I did.
Actually, this is on the way over. And you confirmed that you didn't see any weapons.
I did not see any weapons.
You confirmed that he never moved towards your daughter.
He did not move towards my daughter.
You can confirm that at no point did he make a claim or a threat that he was actually armed.
He did not make a claim or threat. He was actually armed.
For example, if you move that snow, I will stab you with a knife that I have on me.
He never made that claim.
Or a screwdriver.
No.
And here's what we can, now get into this first chapter of when he actually reaches you. You stand up, correct?
That's correct.
This is after you making observations of his pace, of him putting stuff on and not holding anything, correct?
That is correct.
And your claim and you explain to the officers, look, this is not a memory issue, this isn't a sleep issue, that's exactly what he said.
That is correct.
And on this point, you're not confused or lacking any memory, correct?
That is correct.
You use the term verbatim. That means word for word, right?
That is correct.
And even at this point where he's close to the truck, he doesn't make any gesture, any recognition that there's anybody, including your daughter, in the actual vehicle, correct?
No, he does not.
He doesn't reference your daughter specifically?
I do want to point out that we are having to drop the audio there because of the language that is being used in that statement, but it's essentially this defendant saying that the victim told him, if you put snow on my driveway, I'll kill you and your family. We have more after this quick break of Jason Levesque on the stand.
Tonight on Closing Arguments, Sudiksha Konanki vanished nearly 2 weeks ago. Now her parents are asking for her to be declared dead. We'll bring you the very latest in this tragic case.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
We believe the glove was his.
It was a setup.
They weren't fitting him.
If it doesn't fit, you must acquit.
Trial and Error. Why did O.J. win? New episode Sunday night, 8 Eastern and Pacific, only on Court TV.
Watching Court TV Live, we are going to go back into that New Hampshire courtroom where defendant Jason Levesque is on the stand testifying in his own defense. He's a 45-year-old accused of shooting his neighbor over an argument about plowing snow. He was the one who was doing the plowing, and his victim, Kyle Violette, was eventually shot 6 times, suffering debilitating injuries. The state told the court that their surviving witness could not testify because of those injuries. So we don't know if we're going to see anything from Kyle Violette on the stand. But now Jason Levesque taking the stand in his defense case. Let's pick it up right where we left off.
Doesn't reference your daughter specifically, correct?
That is correct.
He doesn't reference her name, right?
That is correct.
And this is the point where you're, quote, nose to nose.
Nose to cheek.
Cheek to cheek. And you say at this point, while you're face to face, nose to nose, you step back a little, you step forward, you step back, but kind of within that, I don't know, arm's length distance, correct?
That is correct.
You claim that he repeated. Okay. So that's twice where he's referred to you needing to do something in the future for him to do something, correct?
That is correct.
And then he walks away, correct?
That is correct.
And now there's a distance of 15, 20 feet between the two of you, right?
I believe so. I believe there was another interaction before he walked that far away. If you'd like to reference the video on this, it'd be helpful.
And you described to the police officers the threats that were made about moving snow when you were face to face.
That is correct.
He then moves away from you, and you told the officers that, you know, I don't know if he repeated it again before he walked off, but he walked off, and then you described what he said. It's page 43, line 19. Got it?
Line 19.
Yeah, you said to the officers, you know, then he walked, I don't know if he repeated it again after those 2 times. And then for some reason he stopped, turned around, was walking away and said, and this is what you told. Just to be clear, you said that also at page 20. Lines 3 and 4. Oops. Sorry about that. Lines 3 and 4. You described it. You know how the detective looped back, you know, asked you about a situation. So on line, at page 20, you said again, he started walking. Explain to the police what Mr. Violette supposedly said about, you don't believe me.
That's
In
correct.
neither of those claims to the police do you say he.
It did include that.
Absolutely. You don't look anywhere because every single time you describe him actually making a threat, it's conditional.
That is incorrect.
Well, you have told the jury what he said was. The problem is you described to the police twice, not once, but twice,
Yeah.
this claim that he turned around and said, what, you don't believe me? And never once said he made an independent threat. Not once.
I don't know. I haven't looked through the whole thing, but I can assure you that he did say it.
You just didn't tell the police about it.
I don't know. I haven't looked through this whole transcript, but I can tell you he did say it, and I'm pretty sure it's probably in there. I've not looked through every page of it.
You're welcome to do that, but you agree with me, these are 2 instances where you specifically bring up that moment where he said, you don't believe me. And he did not add a standalone threat.
No, you're absolutely right. I didn't add that. Again, I was not completely coherent, awake, or remembering everything that was going on. I was doing my best to try and piece this together with them.
You described him having walked away. He gestures to the snow in front of your place. You agree that he's saying, don't move that over to my place, correct?
I believe so. Again, if you'd like to bring the video up and you want to talk about it, I'd have a better understanding of what point we're talking about.
You don't recall, you just described him walking away, correct?
Which he did multiple times, yes.
He actually walks away once, and then he turns back towards you, and that's the moment I want to talk about.
The first time, because he was up close to me, he walked a few steps back and then came back to me again.
Okay.
Are we talking about that time?
Yeah, no, that's the incident in front of the plow. Now when he walks, as I think I mentioned, probably 15 or 20 feet away.
Okay. I just want to make sure we're on the same
Got
incident.
that?
Yeah.
Fair?
That's fair.
At that point, you say he stopped, turned, and walked back towards you.
That is correct.
He took...
Okay, as they delve into this prior interaction just before the shooting, let's bring in our trial attorney who is standing by. Tamika Rabowski is with us. Tamika, the prosecution is making a lot of hay about this independent threat, standalone threat, saying there wasn't one, that this was a threat mixed in with a condition that if the defendant did something, then he would carry out this threat. Do you think the jury is really going to follow that train of thought, that there's this difference between a threat and a standalone threat?
I think that they will, and I think that they have to when there is a assertion, as it is here, that based upon that threat that's the basis for his actions. Because remember, so far all we've heard about is a prior incident that occurred months ago that he didn't find significant enough to even contact the police about, that he has kind of referenced multiple times in his testimony on direct. And now he has to hang his hat on this threat. And if there's nothing independent, and it's just if you put the snow there, then that'll happen. And he knows that he had not put any snow there, then we have no reason for you to feel threatened. So I think that the jury is going to be paying attention to that.
Speaking of his statements, what do you make of the one he made to his daughter that his daughter shared with police, where he turned to her and said, "Should I run?" after the shooting? He says it was a joke. His daughter didn't seem to think it was a joke, but state definitely wants to use it as some sort of consciousness of guilt.
And I think that you have to look at it that way, because that, again, the daughter took it that way, and I'm going to assume that she's sitting there talking to him. She's able to judge his demeanor at that particular time, not after he's been arrested and he's potentially facing charges, which is now when he wants to frame it as a joke and maybe lightening the mood, and it's unfortunate. In any event, the statement is unfortunate, but it doesn't bode well for him in terms of the current charges. And I think the fact that his daughter took him seriously kind of signals that maybe we should too.